Okay. Welcome everyone to this session of the Information Society Law Center conference. I'm Samanta Stanco. I'm a lawyer and a research fellow at the University of Milan. And as you already know, I will be running this session, which is dedicated to digital rights. So as I told you, our session will be shorter than the others because free speakers told us that they can't attend the conference. First of all, I want to thank all the fellows for presenting their very interesting papers. And the session will be divided into two parts. In the first part, there will be a presentation of the abstract, of the extended abstract, and then we will open a discussion. The idea is to give to every single fellow the floor, so they can present themselves, their research lines, and their extended abstracts. Then we will open the discussion. We already received some questions, some comments from the other fellows who read your papers, but we would be very happy to receive other questions during the conference. So you can interact with us writing comments in the chat. Well, I don't want to borrow other time to the speakers, so I think it's better to start. And we start with Beatrice Panattoni, who is presented an extended abstract entitled Harmful Contents Online and Platform Criminal Responsibility. Thank you, Beatrice.
Thank you, Samantha. Thank you. Good afternoon, everyone. I would like to thank the Information Society Law Center for this precious opportunity to present and to share with you my research. I am a postdoc, just a few words about myself. I'm a postdoc researcher at the University of Verona in Italy. I finished my PhD in July 2022, and very recently, and today I'm going to present the outputs of my doctoral research, which I intend to further develop during my postdoc studies. The topic of my presentation is, as you can see, online platform criminal responsibility. So let me start with my agenda for today. Okay, first I will briefly explain the methodology I choose to follow during my research, which is based on a crossroads between criminology and criminal law. Then we will briefly analyze the phenomenon that is the core of the research, so content-related offenses, and the preventive approach in order to regulate this phenomenon. And then we will shift to the possible models of criminal responsibility of online platform, which we can structure following two different perspectives, the one of the user or the one of the provider. And finally, we will see which role remains to play for criminal law within the set of tech policies in the field of online platform regulation. So, from a methodological point of view, we need to distinguish whether we analyze harmful contents online through the lens of criminology or of criminal law. Criminology helps us to describe the common features that at a phenomenological level link the different acts that consist in uploading and sharing harmful contents online. Since we can find these common features, despite from the nature and the significance of the single content, we can treat harmful contents online as a single phenomenon. So criminology then help us in having a more systematic view in order to develop a more effective and proportionate measures to fight and prevent the uncontrolled dissemination of harmful contents online. On the other hand, criminal law requires us to remain in the realm of a strict legal certainty. Therefore, we need to understand which criminal offenses might be realized through the upload and the sharing of online contents, and each criminal offense has its proper regulation. So, On the other hand, criminal law helps us in making the proper distinction based instead of on the nature of the contents uploaded or diffused. The approach I would like to suggest is the one that keeps together criminology and criminal law, making them talk to each other. So, as a phenomenon, harmful contents online present some common features that need to be addressed in order to understand it better. And I summarize these features into 3 keywords: quantity, velocity, and quality. So quantity, we have, as we all know, online a high quantity of materials and a high quantity of actors, both users and platforms, involved in the dynamics that create the dissemination of harmful contents online. Velocity means the quick spreading online of harmful contents due to the easy accessibility to digital tools, but also to algorithmic agents that index those contents, as we already saw this morning in the presentation, the very interesting presentation of Guillermo Migliora, if I'm not mistaken. And the last of this feature is quality. Harmful contents online are fixed in time, remain fixed in time, so they enter in a dimension that is characterized by a persistence in time. And we will see how these features affect the measures and the regulations aimed at countering the spreading of harmful materials on the web. Shifting to criminal law, we can suggest to classify the most relevant criminal offenses that can be committed through the diffusion of harmful materials into 2 main groups based on the nature of the interest on the legal good, the Rechtsgut, that they harm. And this way we have contents against the public on one hand and contents against a person on the other hand. Here I reported some example. For instance, content in the first group, contents against the public, we have terroristic contents, apology or incitement to crime, incitement or to discriminatory based acts. Instead, within the second group, contents against a victim, we have for example, defamation, child pornography, non-consensual pornography, which is also improperly called revenge porn. And both these groups should be articulated through a scale of seriousness based, of course, on a case-by-case approach, since we must follow the EU directives on the matter. Indeed, the Digital Service Act, the DSA, gives us this concept, manifestly illegal contents, which might be useful in order to establish the level of care required to online platform that, as we will see in a bit, must remove those contents, but only if we are able to give to this concept a certain meaning. And of course, this is not easy, especially if we decide to navigate in the criminal law field. So, given these features and the wide amount of criminal offenses that might come into relevance, it is clear that a reactive approach does not suffice in this field. In other words, once the harmful contents are online, the effects and therefore the harms they create are almost always irreversible. Their quantity, their quick spreading, their permanency in time make the capacity to control the phases after the original upload practically impossible. That is to say, in a data-driven society, the capacity of control of a single human agent on the digital processes that create the on-life experiences is ever crumbling. That is why tech policies on the matter cannot be limited to the fight against harmful contents online, but must look also at the measures aimed at the prevention of this criminal phenomenon. If, on one hand, the demand of prevention is due to a social need based on empirical elements, and this is very important in a criminal law perspective, On the other hand, using criminal law as a preventive measures has always been very problematic. I cannot here use too much time on this point, which will require much more discussion. So let us just say that traditional criminal law categories have been built as a reaction to harm. Their use in case of danger or even worse of risk does not easily comply with the criminal law constitutional principles. So, keeping this in mind, we need to understand if there is a proportionate and adequate path to structure preventive measures in the field of content-related offenses, also through criminal law. In order to do that, we need to focus our attention on the private actors that have the actual capability to act in preventing the occurrence of such offenses. And the actors that create, provide, and manage those services where content-related offenses are realized are, of course, as we all know, online platforms. So, here I prepared a short visual explanation of what online platforms are, but I don't think that since I'm talking to an expert group, I don't think we have to spend too much time on this. Is a structure that is based on the framework of the Digital Service Act, and of course we have the broader, the widest group that is intermediaries, and there are different kind of intermediaries. And what we will like to, the category on which I would like to focus my attention is only online platforms. So the smallest group, and especially large platforms such as Meta, Twitter, and so on and so forth. Instead, let me use a little more time on the possible models of criminal responsibility of online platforms. Here, we are forced to think within national legal frameworks, since the competence on the matter is reserved to the member states. So I will use the Italian criminal law system as a reference. As you can see, we can follow two different perspectives. First, we can hold the managers of the platform criminally liable for what the user does. I didn't specify it before, but we are considering the cases where the managers of the platform did not disseminate directly themselves or actively contribute with intent to the dissemination of harmful contents online. So in these cases, we must verify whether we can attribute a criminal responsibility to the platform for the crime committed by its user based on the omission to remove that content. We can use this form of responsibility based on the model of commission by omission only when there is a specific legal obligation or positive obligation that requires the private actor to prevent a particular crime from taking place. We might find the positive obligations in the national law that implemented the e-commerce directive 31 of 2000, that of course is going to be substituted by the Digital Service Act. And this national law, for instance, requires that platforms, as the DSA, once they are actually aware of the illegal content hosted on their services, they have to remove it. However, there are several shortcomings in using this model of responsibility that have been highlighted by scholars and case law. First, using the model of commission by omission to prevent others' crimes is not a model that is well accepted, since it easily does not comply with the requirements of strict legality. It is impossible to anticipate others' behaviors unless you are in a specific position. Think, for example, of the employer with its employees. And of course, the platforms hardly have this kind of position relating to their users. And the second shortcoming regarding this model of responsibility is that we need to establish the intent of the platform regarding both the presence of the illegal content on its service and the decision to not remove it. So, given that also this element, it is very difficult to assert in most cases, there is a high risk to resort to forms of strict liability, which are constitutionally illegitimate in most civil law-based criminal legal systems. So, given the issues that present the first model of responsibility, I think that is better suited to follow the second approach. That is to say, to hold the platform responsible for what the platform does. There are indeed several risks related to the service they offer, and the DSA help us in this regard since it speaks about systemic risks stemming from the design, the functioning, or the use of their services, and I'm referring to recital 79, 80, and especially Article 34. There are specifically 4 categories of risks identified by the DSA. Risks associated with the dissemination of illegal content, risks related to the actual or foreseeable impact of the service on the exercise of fundamental rights, democratic process, public security, public health, and so on and so forth. The definition of these areas of risk and the organizational obligations the platforms must comply with in order to assess and manage them set a standard of care based on a virtuous organization of their services and business. And if lacking, the platform should be held responsible for it. The question now is how. So, if we are to follow the second perspective that I described, holding the platform responsible for what the platform does, since there are not current criminal laws on the matter, we need to shift our discourse on the level of criminal policy. And the paths that can be followed here are threefold. First, a first option would be to criminalize new behaviors. For instance, criminalize the failure to comply with the most relevant obligations required to the platforms by the relevant legal sources, or, for example, the failure to remove an illegal content of which the platform have had actual knowledge of. But in my opinion, this is not a way we want to choose, since criminal law must be always the ultima ratio when it comes to the policy choices, and the shortcomings that I highlighted before will likely present itself also in these cases. A second path will be then to exclude criminal law from the set of policies, leaving this field of regulation to administrative sanctions or civil remedies. However, the seriousness of content-related offenses, of certain content-related offenses, and the social need that I highlighted before of protection against the harms they inflict to society asks for a set of measures that must have a sufficient level of deterrence, prevention, and also re-education. The third way, then, that is a mediation between the first and the second one, is that we might suggest to resort to criminal law, let's say, in a broad sense. In other words, punitive law, focusing on a model of responsibility based not on the single persons, but on the corporations. Corporate criminal law is, my opinion, a perfect example of punitive law, an hybrid form of responsibility based on compliance obligations and administrative sanctions, but that requires, nonetheless, the culpability of the corporation for it to be held liable. So, in conclusion, I believe this might be a suitable solution for the for the field of online platform responsibility, or at least it is a policy choice that deserves to be taken into consideration and more deeply evaluated, which of course I intend to do in the next steps of my research. And I took too much time, and I apologize for that. So thank you very much for your attention, and I look forward for your questions and discussion. Thank you again.
Thank you very much. I think it's a very interesting and hot topic and very actual too. So thank you. We will have the question time at the end of the presentation of the papers. So I kindly ask you to stay here with us in order to collect the questions at the end. Thank you. So we can go on with the next speaker, who is Anastasia Nefeli-Viadaki. Anastasia is presenting an extended abstract entitled Digitalization of Justice in the European Union, Challenges and Future Prospects. So thank you very much, Anastasia. The floor is yours.
Thank you as well. I would like to say hello to everybody, to all the participants and the people that are attending the conference. I think it's high time to also introduce myself a little bit. So once Samantha told you, my name is Anastasia Nefeli-Viadaki. I have obtained 2 master degrees, the first one on Information and Communication Technologies Law at the University of Piraeus, and the second one on Sociology of Law, Science and Technology at the Faculty of Law at the University of Athens. And part of my research was also the digitalization of justice in the European Union, and with a focus on the case of Greece. But today I will also talk more in general about the challenges and the prospects that I see in this field, also with a view of the practitioners, as for the time being I am a trainee at the unit of e-justice at the European Commission. So I will try to somehow merge the point of view of an academician with a person that is involved in policy making. And without further ado, and I hope I will not tire you. I would like also to ask your patience regarding my voice, because I had a sore throat those days. I hope you will understand me completely fine, although I have this issue. As you can see from the title of my presentation, I'm going to talk a little bit about the digitalization in the EU sphere, but I'm not going to just mention legislation, but rather focus on some future developments that I see that are coming. Not only, I would say, in the European perspective, but also internationally, but how we can manage them in our specific area of policy and lawmaking. First of all, I would like to start by telling you that the European Union has expressed since the Tallinn Declaration its political commitment towards ensuring efficient, user-friendly, and really easy access to digital services both for citizens and for businesses. And among those, you can find the provision of unhindered access to justice and cross-border judicial cooperation, which all of us have noticed that it has undergone a digitalization phase. In the fields of civil, in the fields of commercial, and the ones of criminal law, EU has taken already some major legislative steps towards the transfer of judicial proceedings and administration of justice from the analogical to the digital world, accompanied also by some really interesting practical initiatives. I have already included in this slide some of them: the recast of service and documents and taking of evidence regulation, the Codex regulation, the proposals of EU AI Act and the digitalization of cross-border judicial cooperation, the e-justice portal. Those are considered some of the most vital aspects of the EU digital agenda in judicial matters. Um, Apart from them, in the near future, I think we can see that online dispute resolution, maybe with the assistance of algorithms based on machine learning, is expected to give birth to a hybrid process in which the role of new technologies would be tremendous. At the same time, the access to legislation and case law via the internet and the electronic filing and service, the use of video conferencing, along with the prospect of predictive justice, constitute some further matters which should be taken into account uh, before they are vastly applied in the EU sphere. Among them, the application of algorithm for profiling under the auspices of criminal justice is in particular common outside the borders of EU, and maybe I can say it would be likely to be spread within it in the years to come. So in this short presentation, I tried to examine briefly one by one all those future prospects I mentioned, along with the challenges that come with them on a legal but also on a sociological basis, and propose maybe some practical and possible solutions in order to overcome them. Starting with online dispute resolution, I think it goes without saying that the complete submission of the judicial activity to any kind of automated process stays out of question, since it is inconsistent with the right to fair trial, with the access to justice, and with the right of adversarial hearing. However, the latter could be really improved, the access to justice, I mean, from a solution that combines the automation promised by new technologies and with the principle of the natural judge, which we already know, creating in that way a hybrid model of dispute resolution, enabling a more effective and fast distribution of tasks inside the court, reducing the operating costs and the enforcement of and enhancing the enforcement of alternative dispute resolution methods. However, in order to, let's say, hold justice from losing its balancing dynamic between the contradictory parties and not to let it end up as a digital settlement, the establishment of certain guarantees, I would say, is a necessity. First of all, the explicit concept of all the involved parties, followed by the provision of clear and comprehensive information to them, should be a prerequisite, along with the recognition of the potentiality of inaccuracy in proceedings that are run entirely by algorithms. This will, I think, give parties the possibility to challenge not only the decision, but also the scientific validity of the algorithm itself. Apart from that, a judge that is discerning from the algorithmically drawn conclusion should not be obliged to reason specially their opinion or to take greater responsibility. They, as well as the public authorities, with the assistance of the necessary technical staff, should pose those programs, those algorithmic run um, projects under constant supervision and evaluation to determine their effectiveness, their efficiency, and to avoid unforeseen ramifications which would turn against the citizens and indeed against the whole judicial system as such. Apart from that, a first and foremost, I would say, concern of the policymakers in the EU and maybe worldwide is the amelioration of the access to of the citizens to every part and parcel of justice, especially to the legal framework under which it is administrated, namely the legislation and the case law. Unfortunately, aside from some exceptions, the access to both of them requires open data policies, which are not fully implemented in many EU member states, and I would say that are not really popular or in the top place of their agenda. Even if the release of legislation to the public and the accessibility of all databases has not met serious objections, the same does not apply for the nature of databases, including case law. But all of us would wonder why is that the case? In many circumstances, the anonymization of court decisions remains out of question, since the removal of specific facts would render the judgments pointless. So the competent authorities feel sufficient with pure pseudonymization. At the same time, the number, the variety of the content of the information that can be found in a judgment, and the sensitive nature of the data, in combination with the high possibility of cross-referencing, does not, in my opinion, vanish entirely the danger of the identification of the involved parties. And if somebody considers that the mining and the spread of such information would violate human dignity and that allow profiling or discriminatory practices, then we have the potential risk at hand. But I can say that apart from the identification of the parties, the one of the members of the tribunal remains also at stake. Their impartiality, taking into consideration that a gross examination of their public and private information would be feasible, is challenged. As a result, let's say parties or the representatives might engage in unfair practices to achieve a more favorable outcome for their case. And under those cases, the danger of bribery or of the appearance of unlawful circuits within the, the court itself arises. But what can be the solution to this problem? I think that if an anonymization is impossible, then there should be a balancing between the right to access to information by the public and the right to privacy of the parties involved, and this should precede the publication of the judgment. Also, maybe the establishment of a mechanism through which the data subjects could turn to the operator of the database and exercise all the rights that are prescribed under the GDPR would be also another really feasible solution. And now it's time to move on with the electronic filing and service, which all of us can agree that they can facilitate a lot the administration of justice on many levels, but it can give birth to some issues that should not be in any case overlooked. For example, their mandatory nature, if established as such, will pose difficulties to the access to procedures and maybe lead to margin those who are incapable of keeping up with the technological evolution. Um, with whether they are professionals or simply citizens. At the same time, leakage of personal data or cybersecurity concerns arise. And to counterweigh all those negative thoughts, um, I recommend an a priori management of relevant risks with the application of the appropriate preventive measures at the stage of development, as we call it, security by design, and beforehand at the regulatory stage as a security by default, because in this way we would be able to combat those negative aspects and let electronic filing and service flourish the administrative process of justice. And in order not to talk a lot and further tire you, I would say that the same thoughts can be shared and expressed also regarding the mandatory use of video conferencing, since in that case is also the risks and the solutions kindly remain the same. I will go further and talk to you about the predictive justice. It is one of the biggest and most crucial, I would say, aspects of digitalization of justice. Under the term predictive justice, one can understand the outcome of analyzing of a huge number of judgments with the use of modern technologies, targeting at the prediction of the result of the outcome of the disputes that are under examination. As you can say from the definition as such, this type of predictive justice aims to tackle legal uncertainty, namely the risk of the acceptance or the rejection of a claim. I think legal uncertainty is something that is in the core of justice, of the administration of it, but it is quite challenging for all us the professionals who have the desire to overcome it and to provide the best solution for our clients and also for ourselves. So I think that those systems will lead in the future the legal professional and their clients towards the conclusion of the most appropriate agreement in order to avoid a time-consuming and expensive trial, um, or generally the ones that will lead them towards the generation of the most advantageous outcome would be vastly used. Therefore, there is a need for balancing between the legal certainty due to the predictiveness and the creative interpretation of the courts and of the judges themselves. Um, AI systems, till now, as I'm aware of, cannot completely individualize and subsume, so they are restricted somehow to more computational acts, classifications, and groupings. But if a process like this is transferred from a simple calculation to the core of the judicial work, it is probable that it produces a sense of urgency, I would say, a novel kind of normativity, which would operate additional to law, limiting the discretion of the judges, and in the long run, allowing a standardization of the court's decisions, which will no longer base on an individual thinking on behalf of the judges rather than on a more clearly statistical calculation. Allow me to say sterile and most of the times deprived of the human element, which would be constitute a true nightmare for the rule of law. Judges would not reach their judgments according to the law, but the case law trends stemming from the statistics gathered and processed by digital too. Then discrimination, normalization of the majority and its prevalence against an inconcreto and ad hoc balancing and judgment, rejection of the restriction and of the discretion and the limits posed to the principles of independence and the rights to an attorney constitute some of the possible ramifications of the domination of these predictive justice systems inside and outside the court. However, their usage only for the resolution of specific types of disputes with rather, I would say, calculatory nature would be seen as a possible solution, and even that one should call upon consultation of the involved parties, continuous controls, and constant assessment by all the involved factors and stakeholders in order for the judgments to correspond to the legislative amendments and to jurisprudence conversions. And last but not least, I would lend a saying provided by the Dutch Data Protection Authority, which has already warned for a kind of digital fate, the risk that one might not be able to escape from the digital profile created for them. When profiling and all those kind of risk assessment methods are mobilized in the field of security and especially in the field of justice, mainly for the detection of criminals, fugitives, or terrorists, the presumption of innocence, I think, would falter. Even if data regarding a person are gathered normally after they are placed under the regime of the suspect, big data and risk profiling tend to precede overturning the disorder I mentioned before. Those tools, I think, are expected to reproduce unfounded or already existing inequalities and even legitimize policies that are inconsistent with the law and with fundamental rights. At the same time, the main destination of criminal justice tool, which is the rehabilitation of the offender, can be overridden as well. And apart from that, also the role of the judge and of the experts that are take part in the criminal procedure regarding the individualization of the sentence after the examination of the personality of the offender is also quite undermined. However, all this might sound a little scary or a little, I don't know, Orwellian. So we're all wondering if there is any way out of this labyrinth, out of this maze I presented you. I think there is one. A system combining the legal and the digital element, since both of them are constantly developing, following the pace and the disputes of society, should at any time adapt um, to the society without meaning that they should not undergo alternations. Thus, it means that a system as such, um, a system that is still on process, cannot undergo total, disarming, exclusive, unique regulation, but should follow the line of the changes that are already taking place, that are happening right now, or that they are going to happen in the future in our societies. I think the inability to grasp this floating nature by the entities responsible for digital policy, governance, or all those participating in the administration of justice somehow justifies this unending lawmaking as a hopeless attempt to establish normativity and deontology. The shifts on technological and social level present us with new challenges and ask for new, sustainable, balancing, and acceptable by all interesting parties resolutions. Apparently, a few opportunities do exist to combat those negative aspects of digitalization. The attribution of a more human-centric orientated justice, the provision and the application of accountability mechanism, the launch of public consultations, ensuring also that all those skeptical voices are heard, could be the solutions to the aforementioned challenges. Last but not least, the combination of ethics and regulatory measures that do not sacrifice the human factor for the sake of technological deterministic views that tend, to praise speed and effectiveness, also would sound ideal. And I would like to end my presentation with a saying of a famous Greek poet, Yorgos Seferis, who also won the Nobel, and this was part of his Nobel speech. In our gradually sinking world, everyone is in need of all the others. We must look for a man wherever we can find him. When on his way to Thebes, Oedipus encountered the Sphinx. His answer to this riddle was man. That simple word destroyed the monster. Have many monsters to destroy, or I would say tackle or tolerate. So let us think of the answer of Oedipus. And with that being said, I would like to thank you for your attention and your time. And I would be happy to answer to all the questions that you will have after during our discussion.
Thank you very much, Anastasia, for your very interesting contribution. Thank you. So now it's the turn of our last speaker, Sharon. Welcome, Sharon. It's a pleasure to have you here with us despite the technical problems. I can't hear you. I see your mic is on, but I can't hear you. I don't know if you had to give any permission to the system. We don't hear you. Maybe you can try to come again in the meeting. Thank you. So we wait for a few minutes to see if Sharon can attend the conference. I think we could open the discussion in the while. So we have some questions for Beatrice and for Anastasia. Okay, Sharon, we can see you, but we can't hear you. I'm so sorry. Maybe you can stay here with us anyway, and tomorrow you can go to one of the other sessions of tomorrow, hoping you can solve your problem with the microphone. Thank you. Okay, so we can open the discussion. The first question is for Beatrice. Some of these comments are a little bit long, so I can write them down. And you can see. If and when the harmonization of definitions and penalties for hate speech and hate crimes happen, what can be the impact of that on online platforms' internal policies?
Okay, thank you. You can hear me, right? Okay, perfect. Yes, it's a very good question. I believe that one of the most interesting contribute that the criminal law could bring into the discourse, into the debate about touch policies on online platform regulation is that it forces us to distinguish what is illegal and what is disturbing. So we of course we need to remain into a framework of legal certainty. So we cannot base the specific criminal regulations on too broad and too vague definitions, but we have, of course, to be as strict as possible. And that is why I started my presentation between the distinction with the distinction between criminology and criminal law, because criminology, we can use it from a methodological point of view to understand better the phenomenon and to define it with also more broader concepts, broader terms. Whereas if we want to regulate the same phenomenon, we need, of course, to use the stricter tools of criminal law. And with the specific regard on hate speech, the criminalization of certain forms of speech opens a very, very difficult and discussed topic. In my opinion, when it comes to criminal law, it is better to take a step back when we choose to criminalize some forms of speech. That is why I didn't include, for instance, hate speech in my categorization of content-related offenses. In the first cluster, contents against public, I didn't put hate speech because it's not really a criminal offense. It has to be, for example, incitement to crime or incitement to discriminatory-based acts. So we need a more narrow definition. And if we do that, I think that it could be a useful tool for set a standard of care for online platform. But here, of course, we have another big problem, that is the problem of private sensors, because of course if we public authorities decide to delegate the identification and qualification of that specific content as a criminal offense to a private actor, of course it raises many problems because of the so-called chilling effect. So the platforms could decide to simply remove a lot of contents just because it's scared that it's going to answer for it. And in order to find a solution to this problem, I like to think as to the enforcement systems for enforcement measures as a sort of triangle. So we need to think this kind of form, and on each edge we have the user, the platform, and the public authority. So we need to create an integrated system that, of course, is based on the mutual cooperation and collaboration between these three edges. So the platforms, for instance, if it has some doubts about the qualification and the removal of the content, it must be assured a direct link to a public authority that has a specific competence on the matter, in order to ask, within, of course, a strict frame of time, a public contribute in the qualification of that content. Of course, in the case we are always talking about criminal offenses. So again, not a speech in a more broader sense. I hope this answered the question.
Absolutely, thank you, Beatrice. And personally, I agree with your triangle perspective. Thank you. And we have another question for you.
Yeah,
I'm going to show it. Would the DSA or other regulations of that nature benefit from a more strict approach regarding pervasive practices, rather than create a framework that is highly dependent on enforcement?
Yes. Let me just read again the question. Should be held responsible for mismanagement of the services? Yes, actually, I'm a fan of what we call the co-regulation model, because in this case it's actually the only way, because a too stricter approach that is based on a top-down approach leaves us too less autonomy and discretion to the private actors that are required to implement such obligations. So as we saw in the policy choices made by the European Union, the co-regulation model is the more frequent and probably the better suited in this context, because it leaves the necessary discretion to the platforms, of course, within a framework of principles. And I realize that as a criminal lawyer, it's not so easy to say that, because of course for us the clearer the better. So it's kind of challenging for us if we want to include criminal law in the set of measures. But nevertheless, and here again comes one more time the model of corporate criminal law, that is, for instance, based on compliance programs, that is still criminal responsibility, but leaves maybe too much broad discretion to the private actors in order to choose the specific and concrete measures in order to implement the more broader obligations that is required to them by the public. And again, I hope I give you enough answers.
Of course, thank you, Beatrice. Now we have a question for Anastasia. I'm going to show it. Do you think that the online dispute resolution system can be applied to all types of court proceedings equally successfully and efficiently?
Thank you, Samantha, for the question, and it's really an interesting one, and one I've also myself have been going through a lot during my research. I think that we can all agree that online dispute resolution can be really advantageous in some specific circumstances. For example, in cross-border court proceedings, or if the one party is a resident of another country or a remote area in the same country, or in case there are some problems regarding the movement of this party in order to be present at an in-person court meeting. But still remains there still remains the question whether all types of civil or criminal proceedings uh, can undergo a digitalization phase. And in my opinion, it's not feasible for quite some of them, especially ones that are more sensitive, or that, for example, include family or children issues. Some of them can be still held in person if, for example, one party demands it, or if it's easier for them, it can be held online, because in these cases you don't have, let's say, the physical element. It's more abstract, and it's more impersonal, let's say. And this would also be somehow more efficient. But regarding the success of those, let's say, of those efforts, I kind of find out that it depends on the digital infrastructure of its country, and in some cases of its court. For example, I can mention Greece, because it's where I have done my research and where I've also been working as a practitioner. And I have noticed that, for example, in some specific, let's say, civil courts, there is some progress in the digitalization, and in some others there is not. So I guess that in order to achieve success and efficiency, we have to combine both on a more, let's say, regulatory basis, the establishment of some guarantees, technical and also legal ones, so that all courts and all proceedings are equally digitalized. However, in order to achieve that the efficiency part, we should bear in mind that not all processes can be turned into digital, and give the parties the opportunity to preserve the more in person and more personal and more, let's say, human centric version of dispute resolution, meaning the one that is taking place physically and not using digital technologies.
Thank you, Anastasia. Thank you very much. And the second question is a prosecution of the first one. So you have already given an answer, but I show it in any way.
Mm-hmm.
And are there any proceedings in which such a possibility is limited and modest, in your opinion?
Yes, I know that part of this was answered, but if I have the chance, I would also like to add that in all those cases, there are some things that should be taken into account that are, in my opinion, really basic and core elements of the whole process of administration of justice. And with that, I mean the publicity of court proceedings and the openness. So if we want to make them digital, we should make sure that those that are open to the public and those that are going to be held publicly would at the same time be easily accessed by them, which opens a huge discussion regarding the technical infrastructure with which the court itself should be equipped. So I think with that, before deciding to digitalize and to put all the proceedings into their online version, we should take into consideration both, of course, the deontological and the more sociological issues I already raised, but also the practical ones, because those are important and those are the ones that the policymakers, in my opinion, at this specific time should focus on. But yes, with that being said, I think this would somehow be the limit to digitalization, the infrastructure available and the training that the judicial staff has undergone. If those are absent, then we can't even talk about digitalization in the judicial sphere.
Thank you very much. I think this is a very good point. So we don't have any questions. Okay. We have finished our discussion, and thank you very much for your wonderful contribution to this conference. I'm so sorry that Sharon couldn't join us with her exposition, but thank also to Sharon. See you to the next conference. Thank you very much.
Thank you.
Thank you
so
very
much.
much. Thank you.